Well, hello, this is Prof. J for Law 16 Evidence, our late start class, spring 2018, and I wanted to do a short video on week number 1, an overview, to give you some ideas on how to work on it. So I'm going to go ahead and share the screen here, and we're going to go over to week number 1 of the class. And when you do log in, to Canvas, you'll know that there's an overview for each particular week. And here, week 1, there's a number of, you read the syllabus and read 1 or 2 of these law articles. I think it's good to get you ready to do the law class. And here, you should read Chapter 1 and Chapter 2, Introduction to Evidence, Chapter 1, and Chapter 2 on relevance. And then you're going to do number 1, 2, and 3 on relevancy. And then you're going to do the weekly discussion forums. Now, there are 2 discussion forums in week 1. One is introduce yourself. So go ahead and you'll click on here and you'll tell us a little bit about yourself, your family, hobbies, interests, goals, expectations of the class, how you discovered the program. And then go ahead. On this particular forum, you don't have to reply to other students unless you want. On all the other discussion forums, you should go ahead and click on reply to other students. And then discuss the class syllabus. I just want you to read the class syllabus and tell us how it's different or same as the other class syllabuses or syllabi you've read, and what do you find interesting, confusing, or challenging about the syllabus or the class? And that will help to clear up any incongruities or ambiguities, confusions, etc. about the syllabus. There is no quiz in the first week. And by the way, on the textbook, which is the 5th edition, you'll notice, if you click on here on the textbook, while you're waiting to get the 5th edition here, if you click here on the first chapters of the textbook, you'll be able to see that there is Chapter 1, Intro, Chapter 2, Relevance. So read these first 2 chapters for week number 1. All right, so remember to read Chapter 1 and 2, and then do the intro discussion forum and the discussion forum on the syllabus. And then you'll have number 1, 2, and 3 are due in the first week. They're fairly straightforward. The first one, evidentiary objections. Here is a link for evidentiary objections, and it says, in your own words, pick 5 of the objections, summarize it, post what the actual objection is, and then include in it what you think is the reason or the rationale behind each objection. Generally, one can intuit fairly easily what is the reason. For example, facts in the record, objection, Your Honor, the answer is creating material fact which is not in the record. Or here, character evidence, objection, Your Honor, character is not an issue here. Or leading question, objection, Your Honor, counsel is leading the witness. Or objection, Your Honor, counsel is badgering the witness. So anyway, that's fairly simple, fairly straightforward on number 1, assignment number 1. Assignment number 2 is a mock trial material on a hypothetical case, which is a make-believe case. But summarize the facts of the case, select one of the witness's statements and summarize it, and then summarize the law of the case. This is a similar assignment or work type of assignment you might get in a law office, where you're given a case and you need to summarize the facts of the witness statement. So here it is, U.S. versus Monroe, and here are the facts of the case. Here's the applicable law, applicable cases. And then notice that there's a witness statement, several witness statements here. So please just don't copy and paste, like this. Instead, read it and then put it in your own words. It'll be much more relevant and also interesting and challenging, and it will teach you how to summarize either a transcript or parts of a transcript or witness statements. Then the final part here is there are 3 questions on relevance. So read over Rule 401, 402, and 403. And on the relevance rules, you know what I'll do is I'll add in the relevance rules here. I don't think I have them here. And I'll add them to the top so you can read them as part of the assignment. So let's just take a look, by the way, at Federal Rules of Evidence 401, FRE 401, 402, and 403. Here's FRE, I'll put 201, Federal Rule of Evidence 401. Test for relevant evidence, rule of evidence. Evidence is relevant if it has a tendency to make a fact more or less probable here than it would be without the evidence, and the fact is of consequence in determining the action. So a tendency here is anything that moves the needle. It doesn't have to be 40, 50, or 60%, but something, it moves the needle to take a fact that and make it either less or more probable than it would be without the particular evidence. And therefore, it would be relevant because it has a tendency to prove or disprove potentially a, oh, here we go. Here's the relevancy rules. I knew I had them somewhere. So 401, definition of relevance. 402, any relevant evidence is admissible. This is, and obviously any evidence that's irrelevant is not admissible. That's pretty self-evident. And then finally, the 403, even if it is relevant, it can be excluded on the grounds of prejudice, confusion, or waste of time if the probative value, what it proves, is substantially outweighed by the danger of unfair prejudice. So, in other words, even though it's relevant, it's more prejudicial than relevant, and therefore it's excluded. So those are 401, 402, and 403. And let's see. All right, so the first one, in a personal injury case, injury accident for negligence arising out of a car accident, a plaintiff seeks to put on a witness who will testify that he saw the defendant speeding and recklessly passed him about 10 miles up the road from when the accident actually occurred. So here, what you would do, notice that here's the sample answer. It depends because Rule 401, relevancy is determined A, if it has a tendency to make a fact more or less probable than it would be, and the fact is of consequence. Here, in the case of proof of speeding, it can show a tendency of reckless behavior, right? So it has a tendency of reckless behavior, but in fact, it no way shows a direct correlation at the time of the accident because it's not an absolute given that just because a person was speeding 10 miles before means that they were speeding. But it could show a tendency to have a reckless behavior, which then the jury could take into account with respect to the overall evidence that's being submitted in the case. All right, suppose the judge in the question suspects that the witness is lying. May the judge exclude the evidence as being relevant. Actually, the finder of facts is the jury, and therefore the jury has to determine and weigh evidence and determine whether or not they believe the witness is lying and not the judge. Here, no, because there is no objective basis on the judge expecting the suspect to be lying. Relevance cannot be determined by any argument or decision that has no argumentative foundation. And the finder of fact is the jury and not the judge. All right, final one. Plaintiff's deceased was a passenger in a car that was hit from behind. The gas tank exploded, killing deceased. Plaintiff brings a product liability against the manufacturer for negligence in design of the car. So the issue at hand is negligence in design of the car. The person then who caused the accident pleaded guilty to involuntary manslaughter when admitted to going about 68 miles per hour while texting on the freeway. So in fact, this is an admission that the person was speeding. The evidence of the faulty skills to drive are admissible in a civil action. And this is, of course, up to the judge. The fact that the faulty driver admitted doesn't make the product negligence case, that is the fact that the car was negligently designed, either greater or less because the person admitted they were speeding while texting. That is independent from whether or not the driver admitted fault to the accident. You can argue that if the gas tank didn't explode, that there was a chance that the deceased would still be alive from that accident. So you might be able to tie in the 68 miles per hour, but it wouldn't necessarily prove that there was negligent design or product design of the particular gas tank. And so that's it for all of the work for week 1. I hope you're going to enjoy the class. And that now concludes our video.